Call the Committee of Commerce and Labor to order. Clerk, take the roll.
You have a quorum, Mr. Chair.
Thank you. I have 3 bills that the patrons have requested to strike. I'm just seeing if any of them are on the agenda here. I have a motion on Senate Bill 517 at the request of the patron to strike that bill. Second. Been moved and seconded that Senate Bill 517 be stricken from the docket. All those in favor, clerk, open the roll.
Ten ayes, 0 nays.
That bill is stricken. I also have another bill to request of the patrons, Senate Bill 283 be stricken from the docket. Been moved and that bill be stricken. All those in favor say aye. Or clerk, open the roll. Okay, that bill is stricken. And then one final bill, that's Senate Bill 23. At the request of the patron, that bill is to be stricken. I hear a motion. Been moved and that bill be stricken from the calendar. All those in favor, clerk, open the roll. We'll get used to this.
11 ayes, 0 nays.
Are they on the docket? Are they on the docket? Okay. Okay, those bills have been stricken. I have 2 more bills. I'll entertain a motion in a block. Senator Favola asks that Senate Bill 42 and Senate Bill 736 be stricken from the docket. Second. Been moved and seconded that those 2 bills be. Clerk, open the rolls. Okay.
10 ayes, 1 nay.
Okay. Okay. All right. We'll make that change, Senator Sproul. Okay. All right. Those bills have been stricken. I have a motion after looking at the bill on Senate Bill 17 to be re-referred to Committee on Courts of Justice. Do I hear a motion? Been moved and seconded Senate Bill 17 be re-referred to the Committee on Courts. Clerk, open the roll. Okay. Close it.
12 ayes, 0 nays.
Okay. We will go, and I'm not to, but Senator Edwards is not here, so Senate Bill 297 will go by for the day. Oh, wait a minute. I have an indication Senate Bill 297 needs to go to Finance. So, been moved and seconded that Senate Bill 297 be referred to the Committee on Finance. Clerk, open the rolls. Okay, close the rolls.
11 ayes, 0 nays.
Okay, that bill. And I have another one, Senate Bill 536, be re-referred to the Committee of Courts of Justice. Been moved and seconded that bill. Clerk, open the rolls. Okay, that bill. Oh, okay. All right. Okay, clerk, close the rolls. Okay, that bill is out of here. Let's see, who do we have? I do have a request. Senator Black has an appointment, and normally we take committee, but Senator Black, if you want to do Senate Bill 283 for us. I'm sorry, what bill do you have, Senator Black?
This is Senate Bill 384.
384. The committee pay attention to Senate Bill 384.
Basically calls on the department on PDOT to convene a working group of stakeholders and look at some problems that they're having with buried fiber optic cable, and there are no financial implications, no specific requirements beyond that. We seem to have no opposition. I think we've got folks to speak for it if you want. It's basically sort of a mandated meeting.
Okay. Are there questions for the patron? Senator Cosgrove.
Thank you. Senator, do you have two bills that are the same? Was that just a
We,
mix-up?
there was an error made and one of those was stricken.
All right, thank you very much.
Any other questions? Senator Sproul.
Move report.
Bill report. Is there any opposition to the bill?
I got it. I got you.
You got me.
15 ayes, 0 nays.
Thank you, thank you.
Don't have to sign that list, but I can certainly see Senator Barker.
Thank you, Mr. Chair. I believe I have two bills before the committee today, one of which I would like to have stricken. That is Senate Bill 395.
Been moving a second that Senate Bill 395 be stricken from the docket. All those in favor say aye. Any opposed? That be recorded. Okay. Clerk, open the roll. Close the roll.
15 ayes, 0 nays.
That bill is stricken. You're 1 for 1 so far.
All right, hopefully it continues that roll. So, but anyway, the second one then is Senate Bill 418. What that bill does is require that by July of 2020, all the 911 systems across the Commonwealth would have to have the capability of accepting text messages. This is technology that's relatively simple, and one would have thought we would have achieved that by now, but that has not occurred. It actually got a good bit of attention during the shootings at Virginia Tech in April of 2007. There were a lot of students who were under desks and things that didn't want to make a call and create the noise that might attract the gunman. But there was no system in place in Montgomery County to be able to handle those texts. So many of them ended up texting friends or parents and tried to get them to be involved, but it clearly was not as effective as it would have been otherwise. And it was a recommendation of the Virginia Tech incident group, management group that recommended this being done statewide. There are a number of jurisdictions around the state, and pretty much all the large jurisdictions have this in place now, but many do not at this particular point. There have been grants that have been available to those jurisdictions that wanted to implement it. And now the FCC now provides a requirement that if a locality wants to do it, and they can, that the cell phone companies themselves have to pay to have that implemented. So cost is no longer an issue here. It's something that is particularly beneficial to the limited hearing and deaf communities, as well as in situations such as occurred at Virginia Tech in 2007, when people wanted to be able to communicate but were afraid to make a phone call to do so. What this would do is put it in place so that it could all systems throughout the Commonwealth would be able to have this system in place. I do have some students who have been working on this issue, like to testify on it, and I'd be happy to answer any questions if the committee so chooses.
Other questions for Senator Barker? Senator Inman.
Some areas have not had 911 for a long time. Do all the systems upgradable and prepared to do this, or is this going to be a technology leap for?
This is not a technology leap because this did not put you into a new technology. I think Senator Suderline has a bill to put them in, all of them into a new technology, but that is several years down the road. So this is just a simple system and allows them to be able to text directly into, with simple technology. The jurisdictions that have it have found that there aren't a lot of people that are using it now, because there's fairly limited circumstances where it's necessary to. And in fact, Mr. Chairman, my understanding is in Virginia Beach, they average about 1 text a day right now. So,
Thank you. Are there other questions for Senator Barker? Senator Barker, you look like you have a whole group behind you ready to come talk to us, so I'm asking them to be brief, but please.
I've suggested that as well. So, but they clearly have done a lot of good work on it.
Absolutely.
So come forward.
Yes, ma'am.
My name is Tu Lee, and I'm going to be talking about why this bill would save lives. And obviously, we know that over the years, texting has become a fundamental way of communication, especially among people under the age of 20. And not saying that people over the age of 20 don't text, but we millennials text a lot more. And actually, in 2010, the FCC asserted that 70% of 911 calls came from mobile phones, and that texting itself has increased more than 8,000% over the last decade. And in this situation, like, there are a lot of people who would, what's the word? Like, they need to text because, like, people with autism, speech disabilities, cerebral palsy, and other conditions such as that. And one example is during the Pulse shooting of June 12, 2016, a man named Eddie Justice, who was there, he was a victim of that shooting, and he was unable to reach 911 because he feared that calling would draw too much attention to him. So.
Well, thank you. Thank you very much. Yes, sir.
Hello, my name is Rodolfo Ficini, and I just wanted to say like why this bill would be good for Virginia. So, in addition to what our senator has talked about, like the Virginia Tech shootings that affects like the universities of Virginia, VITA has also specifically recommended 911 services to be able to text text back to the people. And Vienna and Clifton, which is an area in Northern Virginia, through Verizon, Sprint, AT&T, and T-Mobile, are able to like send these messages to and from the users, because the 911 service is intended for people who are hard of hearing, unable to speak, or in a situation where it is not safe to call 911 or in a remote location with limited voice network.
Thank you, Rodolfo. Yes, sir.
My name is Daniel Strauch, and I wanted to talk about how cost would be an issue for this bill. However, cost isn't very much of an issue for this bill. As the senator mentioned, the FCC has already mandated that PSAPs reach the technology required to be able to receive text messages for 911, people who require 911 services. And the technology needed is not that complicated in the first place. It is basically, it uses public, it can be used through public internet. And I also wanted to point out that text traffic would not likely overwhelm the call takers, and that text can be easily transferred from one call taker to another through dependent on their handling equipment.
Thank you, Daniel. And Senator Norman,
Yes.
appreciate you wearing the pink tie today.
That's
Senator,
right.
Senator Norman's known for wearing pink ties, and
Oh,
that's exactly right. So,
Thank you.
Well dressed. Thank you, Daniel. Yes, sir.
Good afternoon, ladies and gentlemen. My name is Arkham Azunder. I'm here to talk about where this bill has been successful and why. First, I'd like to assert that this bill is beneficial for victims involved in kidnapping, sexual assault, or abusive situations. And I'd like to fully assert that any misuse of a 911 text message will be followed through according to the Virginia Code. Any abuse via text message will also face the same punishments as someone who abuses the 911 service for calling as well. I would also like to reiterate what my associate tried to say with the 4 U.S. wireless carriers, in the sense that AT&T, Verizon, T-Mobile, and Sprint committed that ever since 2014 they would make text 911 services available in all networks in all counties. I have some data from the FCC stating how many counties already have the 911 text service available. In Arizona, they have 136. In Alaska, they have 177. In California, they have 591. In Texas, they have 674. But in Virginia, even though we have 119 counties, only 35 to 36 have the text 911 services available. So we believe that, along with the senator and the rest of my associates, that it's imperative to have the 70 to 80 PSAP services upgrade to the latest technology with a fraction of the cost. Thank you.
Thank you very much for your input. Senator Barker, you brought a well-versed crowd with you.
I did, and one even wearing that pink tie. So,
All right.
so.
Is there, Senator Norman, is there anyone opposed to this fine piece of legislation? It's been moved and Seconded that the bill be reported. Clerk, open the rolls. Close the roll.
13 ayes, 0 nays.
Okay.
Thank
Two
you,
for
Mr. Chair.
two.
Yes.
Well done. Thank you.
Don't worry.
Jeremy, come on up.
Thank you, Mr. Chairman. Today I have Senate Bill 654.
Committee, pay attention. Senate Bill 654. Go ahead, Senator McPike.
Senate Bill 654 seeks to require the inclusion and installation, keeping of AEDs, which is automatic external defibrillator devices, in health or fitness centers in Virginia. Since 2002, the American Heart Association and the American College of Sports Medicine have issued recommendations for the presence of AEDs in health and fitness facilities. A couple key facts as to why it's relevant. Compression only without an AED or with AEDs present has a survival rate of roughly 40%. It drastically increases the survival rate. With compression only, survival rate is 8.7%. Folks that are engaged in exercise are 15 to 20% more likely during vigorous exercise to have a serious cardiac event in terms of when the events are likely to occur. So one doctor recently quoted that a health club without an AED program is like a pool without a lifeguard. 1 out of 4 health club members are 55 and older, and has increased since 5% since 2012. So any of those of 55%, just saying, those who have applied the New Year's resolution, be wary, take it easy. But another interesting fact, a recent study found that survival rates reached 93% in centers equipped with AEDs compared to 9% of centers without. So those are pretty drastic survival rates and statistics. Being in the fire and EMS service over the last 18 years, some of the key statistics we deal with are survival rates for cardiac arrests. Your survival rate decreases by 7 to 10% each minute lapse without an AED present. Compression sort of by time, but really the survival rate as well as the neurological damage done decreases for each minute passed. So it really is access to the AEDs, one of the critical components of this bill. To date, I only heard one concern about the bill from the International Health and Racket and Sport Club Association, and that was in relation to liability in Good Samaritan laws. And I pointed to our code section in Virginia, which has covered it for the last several decades on Good Samaritan actions and how this is covered in this sort of circumstance. So that is the bill, Mr. Chairman.
Are there questions for the patron?
Mr. Chairman.
Senator Cosgrove.
Thank you. Senator McPike, there are a lot of these anytime fitness places that are 24 hours, use your key card, and they don't have staff on hand.
Mm-hmm.
What happens there?
Well, the AEDs now are basically anybody can apply and use. I mean, they walk you through, you hit the button, all you have to do is power it on. Really the fundamentals, if there's some discomfort around it, it really is having access to it. So if you had discomfort about ensuring staff, there would be a remedy to the bill by striking lines 75 through 79 in terms of the requirement of online in-person staffing trained. Simply having access is one of the keys. And so a bystander, by powering it on, it'll walk you through verbally on exactly all the steps to do.
Mr. Chairman.
Senator Cosgrove.
Thank you. There are anytime fitness, other places that do not have people on staff
Right.
after hours, et cetera. So at a minimum, we would need to make the amendment, striking the language you just did, because basically it says you have to have one employee there who's certified in the use of this equipment. And so basically that would put every one of those places out of business, really.
Yeah, so I think the committee's amendments would be to strike lines from line 74, starting with in addition, down through the remainder of line 79, as well as lines 70, I'm sorry, as well as lines 56 through 58, which is simply a definition used in that section, and that would clean it up.
I'd make that motion, Mr. Chairman.
It's been moved and seconded that the amendment to strike lines 56 through 58 and lines 74 through 79 be made. All those in favor say aye.
Aye.
Any opposed? Okay, those lines are stricken. Senator Cosgrove, does that
I'm done, sir. Thank
complete
you.
your concerns? Any other questions to the patron? Do you have anyone here to speak for the bill?
No one can make it today.
Okay. Is there anyone here opposed to the bill? Seeing none, the committee operates by motion. Been moved and seconded to report Senate Bill 654 is amended. Clerk, open the rolls.
You're giving me a heart attack up here.
Okay. All right, clerk, close the rolls.
11 ayes, 4 nays.
11 ayes, 4 nays. The bill's reported. Thank you,
Thank you,
Senator. Are there any other? Senator Deeds, good to see you.
Got Senate Bill 690.
I'm sorry, Senator Bill what?
Senate Bill 690.
Senate Bill
This bill was
690.
generated from a
690.
a constituent based on experience staying at a hotel. Hotels routinely put a hold on debit cards in an amount greater than the actual room charges, and that makes sense because they have to cover in-room fees, damage, et cetera. Gas stations do it sometimes too. For a consumer who uses debit cards, this can be problematic depending on the amount and the length of the hold, as this limits access to actual funds in his account. Generally speaking, the merchant sets the amount of the hold, the bank sets a time frame for the hold, and the card network set outside limits on hold. Rather than try to set a limit on the holds, this bill simply requires merchants to notify consumers if the hold is more than 25% of the room charge or $50, whichever is greater. If the amount's unknown, or if the amount is known, the merchant discloses the amount. Now, this has been the law in Tennessee since 2006 and in Connecticut since 2014. And I'd ask, I'm here to answer any questions.
Okay. Questions to the patron. Senator Norman.
If somebody's got a $50 hole on it, I'm just thinking about proportionality, knowing a little bit about for that Virginia Consumer Protection Law. I know there are certain situations where you can get treble damages, but I'm more concerned about the attorney's fees aspect on it. Would that be applicable in this situation?
I've not thought that through, Mr. Chair, Senator Norman. I don't know. The constituent wanted a bill that prohibited this or set a strict limit on the amount. But when I looked around what other states had done, it made more sense to me just to have disclosure. Simple. And this bill nearly is word for word to what Tennessee and Connecticut have done.
Okay. Is there anyone, do you have anyone to speak in favor of the bill? No. Is there anyone opposed to this bill?
Mr. Chairman, members of the committee, Joe Words, Virginia Restaurant Lodging and Travel Association. We do have some concerns with the bill, especially as it's written. It is common for hotels, obviously, to put a hold on transactions with debit cards for a variety of reasons. A majority of hotels do already disclose that at the time of check-in, that a hold will be placed on a card when a debit card is given to them. And so the disclosure, as it's written in the bill, is pretty vague in terms of what that would look like. So we do have some concerns with this moving forward. Thank you.
Okay. Are there others opposed to the bill?
Mr. Chairman, Mike O'Connor, representing petroleum marketers and convenience stores. Our concern was based upon line 182 of the bill. Talks about gas pumps. Number one is not defined in the code as it is described here in this legislation. Also, I'd point out 59.167.1 has many requirements for pumps that need to be labeled, such as brand name, grade blend, octane, percentage of ethanol, no smoking. So we're talking about, with all these requirements, adding a new one onto that dispenser, I think is going to limit the information that's gathered from those that are really the most very important. Secondly, the last point I would make is there are two ways to avoid a hold. Number one is to use cash, and number two is to do a PIN debit. My understanding is the only time that the holds are put on is when you use your debit card as a credit card.
Thank you.
Thank you.
Are there others?
Mr. Chairman, members of the committee, Kate Baker with the Virginia Retail Federation, and we want to echo the same concerns of VRLTA and what Mike just said.
Thank you.
Mr. Chairman, Nicole Riley with NFIB. The one concern that I'll bring up that maybe hasn't been brought up other than by Senator Norman is it does put it in the Virginia Consumer Protection Act, which we do feel would expose a lot of small business owners to legal action. Thank you.
Thank you. Any others? Senator Deeds, you want to wrap up? You pretty much said it all?
I pretty much said it all. This bill is not one that limits the amount of money they can hold, or it doesn't. It says if it's more than 25% or $50, whichever's greater, they've got to disclose it. That's all it is. All it says. Other states have done it. I'm not sure if Tennessee or Connecticut have seen any negative repercussions from this legislation, but that's the bill.
Okay. Committee operates by motion.
Move approval.
It's been moved and seconded that the bill be reported. Clerk, open the rolls. Close the rolls.
6 ayes, 8 nays.
6 ayes, 8 nays. The bill
thank
fails
you,
report. Thank you, Senator Deeds. Any other non-members? All right. Who on the committee wants to go first with their bills? Senator Obenchain. You have Senate Bill 536.
536, I think, is one that we're asking to be re-referred.
Have we done that already? We have. Okay, then Senate Bill 542.
Yeah, Senate Bill 542 deals with domestic surplus lines insurers. In Virginia, there are two options for a Virginia company that offers surplus lines. And quite frankly, it imposes a burden on Virginia companies that isn't imposed on other states. They can either operate as an admitted company or a non-admitted company. And if they're an admitted company, they can, and I'm probably going to get this backwards, but my understanding is that they can offer their surplus lines in Virginia. If they're non-admitted, but not in other states, if they're non-admitted, they can offer in other states, but not in Virginia. And it requires them to set up a separate company if they want to offer the surplus lines in other states. There is an alternative. Other states are adopting domestic surplus lines laws, which allow a company domiciled in that state to offer their surplus lines both in the state that they're domiciled in and in other states. And Illinois and other states have done this. Virginia has not, which puts our companies, our surplus lines insurers at a competitive disadvantage to other states. This simply levels the playing field and allows Virginia surplus lines insurers to compete under the same terms that their brother and sister companies in other states are operating under. So with that, Mr. Chairman, I would also point out that we've got a line amendment, and I don't know whether you want to circulate those or report it.
Clerk, could you report the line amendment?
Mr. Chairman, there are three amendments. On page 2, at line 67, after the stricken word unlicensed, strike A and insert an eligible. So it would read an eligible insurer, ineligible, not admitted insurer, I'm sorry. Also on line 173, on page 3 of the bill, after the word right, insert the types of. And the final amendment is also on page 3 at line 174. After introduced, strike an eligible non-admitted insurer is authorized to write, and insert a surplus lines broker may procure with a non-admitted insurer approved by the commission.
And I believe all these are technical amendments.
Okay.
Don't change the substance of the bill, I believe. I would move the amendments in a block.
Been moved and seconded. Those amendments be agreed to in a block. All those in favor say aye. Aye. Any opposed? Okay.
Mr. Chairman, I would tell you that an insurance company in my district, the Rockingham Group, has worked on this with the Virginia Bureau of Insurance, the Property and Casualty Insurers Association on this legislation for the past year.
Okay, thank you. I think Mr. Legault is ready to talk.
Jump on my bill.
No. Chris Legault for the Property Casualty Insurers Association and Chubb Insurance Group. Just want to say we're very much in favor of this bill and urge you to support it.
Okay. Is the Bureau here?
So I didn't screw up the description too bad.
No, you did. Fine.
Yes,
Don Beatty with the Bureau of Insurance. We have no problems at all with this bill.
okay. Is there anyone opposed to this bill? Committee, been moved and seconded that Senate Bill 574 be reported as amended. Clerk, sorry, 542. Clerk, open the rolls. Close the roll.
15 ayes, 0 nays.
Okay, that bill is reported.
Well, thank God I don't have to explain that one more time.
All right, who else from the committee is ready to go? Senator Dance.
Mr. Chairman, I have,
Senator Dance, you have Senate Bill.
Before we
Oh,
do
I'm
Senator
sorry.
Dance, do you mind if I need
Not
to get
at
back
all. I
to
apologize. Senator Dance.
general laws? So
Senator Wexton.
thank you, Mr.
You have
Chairman.
a couple of bills here.
I do.
Senate Bill, which one do you want to do first now?
Why don't we start with 419? We'll
Okay.
just go in order.
Committee, pay attention. Senate Bill 419.
Thank you, Mr. Chairman, members of the committee. Senate Bill 419 is an equal pay bill. Women deserve, I think we can all agree that women deserve equal pay for equal work, but Virginia women are paid only 78 cents for every dollar paid to men, and minority women are paid even less. The wage gap for mothers versus fathers is even greater. According to the National Women's Law Center, mothers in Virginia earn only 67% of what Virginia fathers earn. And this, despite the fact that we ostensibly have an equal pay law, but it's lacking in two important respects that this bill is seeking to remedy. First, this bill would include benefits and privileges such as retirement, deferred compensation, paid leave, and insurance that as compensation in addition to cash wages, which is all that the current law provides for. Second, many employers have policies that punish employees for voluntarily sharing wage information with other employees, and this bill helps ensure that women are paid fairly by preventing retaliation against employees who share information. Because as we all know, information is power. The wage gap impacts women as soon as they enter the workforce. It expands over time and leaves older women with a gap in their retirement income. This wage gap cannot be explained by personal choices. It exists across industries. It exists regardless of education level. And this is an attempt to help remedy that problem. I know there are a number of folks here who are in favor of this legislation.
Are there questions for Senator Wexton? Senator Norman.
Senator, do they already require this on a federal level?
Senator Norman, there is federal legislation that deals with equal pay, but those are not things that that individuals are always able to receive remedies about. Remedies at the state level should also be available if federal action is too difficult to obtain.
I knew the answer.
Are there other questions? Okay, I can see a host behind you. Senator Obenshain.
But under the federal system, I mean, isn't there a federal advocate to actually carry these claims for complainants?
Mr. Chairman, Senator Obenshain, I will defer to some of the witnesses who have a little bit more knowledge about specifics of employment law, the federal versus state. But in my experience as a litigator, I can tell you that proceeding in federal court is always much more challenging than doing so in the state court.
And, Mr. Chairman, and I'm not talking about the litigated solution, I'm talking about the administrative process, the EEOC, and the administrative process, I thought provided administrative assistance, but I'm more than happy to listen.
Okay. Other questions for the patron? Okay, Senator Wexton, I can see him lined up. Yes, sir.
My name is Robert Field. I'm with the Virginia Department of Labor and Industry, and the Governor supports this piece of legislation. You're correct. The Department of Labor and Industry does not have anything currently that is administrative remedy in this area.
Senator Obenchain.
Senator Obenchain.
But aren't these kicked over to the EEOC?
Currently, that's what we do. If people call, we tell them they can call the EEOC. But the expansion of the benefits and privileges added to this act certainly benefits it, as well as the wage information.
But those,
Senator Obenchain.
but you've got both, and I'm just trying to get my head around this, and I don't know whether somebody in line behind you can answer this question or not, but there's a difference between the remedies that are available and the administrative assistance. My understanding is that, to Senator Norman's point, the federal remedy is available under federal law for somebody who's treated unequally on the basis of compensation. But also, there's the administrative process by which, the federal administrative process actually provides that assistance to somebody who's made a complaint and is not being treated equally. And this doesn't, give you the resources, I guess, under state law, at least at this point, to provide that administrative assistance.
That's correct.
But it does provide a parallel cause of action under state law. So our state courts would have that ability to adjudicate that.
That's my understanding.
All right.
Okay.
I got you.
All right. Other questions? Yes, ma'am.
Thank you, Mr. Chair, members of the committee. Anna Scholl with Progress Virginia. On behalf of the Women's Equality Coalition, we strongly support this legislation. In particular, I wanted to draw your attention to two provisions. The first is the provision that would prohibit employers from retaliating against employees who voluntarily share their wage information. We know from reports from women in the workforce that one of the barriers to women learning that they are being paid less than their colleagues is having access to that wage information. And what Senator Wexton's bill says is that should employees share their wage information with each other voluntarily, that's not an action that can be retaliated against by their employer, making it more difficult for women to know when they're being paid less. And Senator Obenchain, to your point, Senator Wexton's bill would also eliminate an exemption under Virginia's current statute that exempts employers covered by the Fair Labor Standards Act from being covered by Virginia's current equal pay statute. And we think that is really important to leveling the playing field in Virginia and making sure that, as Senator Wexton noted, Virginia employees have a cause of action under Virginia law. It can be intimidating to try to figure out the complexities of the federal legal system as opposed to consulting folks who are in your immediate community.
Okay. Thank you.
Hi,
Hi.
my name is Galina Vachena, and I'm here for NARAL Pro-Choice Virginia, and we support this legislation.
Thank you.
Hello, my name is Margie Del Castillo. I lead the Virginia Latina Advocacy Network, and we're here to support this legislation as well. Thank you.
Thank you.
Mr. Chairman, Senators, I'm Charles Summers, a Presbyterian pastor, part of the Presbytery of the James Public Policy Working Group, and the father of two daughters who work in Virginia, and we support this legislation.
Thank you.
Mr. Chairman, I'm Lucretia Fargo with the Virginia Interfaith Center, and we strongly support this bill.
Thank you.
Mr. Chair, Jennifer Allen with Planned Parenthood Advocates of Virginia, and on behalf of the women who need an equal playing field that we serve, we strongly support this legislation. Thank you.
Thank you. All right, Senator Weskin, let's see if there's anybody opposed to this legislation.
This is rich.
Mr. Chairman, members of the committee, Nicole Rowley with the National Federation of Independent Business. We are here in opposition. While we support equal employment opportunity and appropriate enforcement, we do believe that there are adequate pay protections that already exist both at the federal and administrative levels. When you look at the data that talks about the 77% men's earnings, if you actually look at looking at that and taking into certain variables such as time off or maternity, education, child rearing, flexible work arrangements, part-time work, et cetera, the real gap shrinks to about 7%. We also believe that the provisions that deal with retaliation could open up small businesses to litigation, which is costly, and many of them are ill-equipped to handle. Thank you.
Thank you. Others?
Mr. Chairman, members of the committee, Ryan Dunn with the Virginia Chamber of Commerce. Obviously, we're not here to argue the title of this bill. We have very big concerns with how this bill is applied. We agree with equal pay for equal work. We have that in our code already, 40.1, 28 through 28.6. It mentions that specifically. The real danger that our employers have seen with this is removing us from the FLSA. The Fair Labor Standards Act is a unified body that helps us across the board. Everybody knows where they're participating. And the issue, another issue in here is the attorney's fees. Substantially, it actually changes this and says that if you substantially prevail versus where we normally have seen total prevailing, there's a lot of opening our employers up to a whole lot of litigation is the concern with us. We do have great concern with also the benefits and privileges and how you apply that among classes and really to define what is a privilege and what is a benefit goes well beyond just looking at a number of pay for equality. So, we just have some issues with how it would be applied. Thank you.
Thank you.
Mr. Chairman, members of the committee, Kate Baker on behalf of the Virginia Retail Federation, and we also oppose this bill based on the reasons that have already been mentioned.
Thank you. Are there any others? Could I get the gentleman from the Department of Labor? Is he still with us?
I believe so.
Yes, Senator White.
I've had some dealings with you all in terms of people who do not get paid, and the standard thing is you don't have anybody to really investigate. How, when you get a complaint, do you log that complaint in before you act on it?
We log phone calls and all the contacts we get on various issues.
Okay.
And then we take in complaints. We decide whether there's validity to the complaints from there.
So do you feel like you got staff to handle this?
If it was added in such that we did have enforcement requirements to do this, then we would certainly need additional staff. But as is currently drafted, I don't think we need any staff to do what it's required.
Why would you say you don't need any staff? I mean, to me, adds significant. Well, let me ask this question: How many complaints have you received from women about unequal pay?
We refer those to the EEOC currently.
That didn't answer my question. How many of those complaints?
We have not had a great number that come in. Mostly it's handled.
So it's not been a big problem?
It has not been a huge problem for us under the current circumstance.
I guess my question is this, is the times I've had dealings with you, the problem's always been when we try to follow up with people who haven't gotten their wages, which is something I've been working on and that kind of thing, following up. You just don't have the staff, and I've heard consistently over and over again, you don't have the staff to follow up. Now we're going to add whole nother requirement onto this, and I'm wondering how you're going to staff this, although it doesn't sound, at least from what you said, that it's a big problem at all, and that you haven't received hardly any complaints at all.
I'm trying to look for the language of the bill, and I don't see in here where it requires us to take any enforcement action under the terms of the current law. So that's one of the reasons we refer to EOC right now.
Okay.
Thank you.
All right, thank you.
Mr.
Senator
Chairman,
White, would you like to wrap up?
just in closing, I would point out that
Excuse me, just a minute. Senator Crosgrove.
Senator Weston, I'm looking at the body of the bill. Let's put this hypothetical out there. You have a factory setting. You have somebody making a widget, and you have a whole line of people making a widget. One person's been there for 10 years and is making 50 widgets a day. Somebody's been there for 1 year and is making 50 widgets a day. Under this bill, would that newer person be required to be paid the same as a person that's been there for 10 years with seniority?
Mr. Chairman, Senator Cosgrove, I guess it would depend upon what the compensation scheme is that's been adopted by that employer. Is it something that's based on a seniority system? That's exempted. Is it something that's based on the number of widgets that are manufactured by the particular individual? So it depends. It depends. But if it's all equal on every other in every other respect, then they would have to start at the same salary and have a similar compensation schedule.
Mr. Chairman?
Senator Cosgrove.
And I understand that. I guess my only concern is we always run into a problem with what we call compression. And that's people who have been there a good while, have been there with the company, et cetera, and they have seniority. But especially we run into this with, well, in our case, the police department. You know, we had officers that have been there for, I don't know, 10, 15 years. A new officer's coming in, they do the same job, but the new officer is getting paid almost as much as the officer that's been there all that time. And it creates a lot of hate and discontent within the whole employee structure. That's my concern.
Mr. Chairman,
Senator Sproul.
speaking to the bill. Speaking to the bill.
Yes.
I'm here trying to understand why men have a problem and women folks getting the same pay. Number one, I'm looking up here, I wonder why in the Senate, the money that we get, that I give to my granddaughter, she gets up, I think, 18,000? 18,000. So I think it's 18,000 I give to my grandkids. So why is it that we get 18,000 and you get 18,000 and Rob get 18,000? Why we don't pay the women less? Point one. Why is that? Number two, every female who spoke up here worked for some company. They're not for themselves, they're for the company they're working for. Number three, I retired from Verizon. I do pretty good. I almost live like Senator Norman. That's my friend. With Verizon, when you went from an installer to a PBX, and they gave the pay based on the job title, not that you're a female or male. Job title. If you're a PBX installer, whether you're a man or a woman, whether it's beginning or sixth, they gave a guideline, and they gave the pay based on the title, not that you're a woman or man. I thought that black folks had it hard. Because I'm saying, what's the problem that in this state we are constantly giving women a hard time? So my question to my colleagues up here, just suppose is that there's a job, the exact same kind of job. The exact same kind of job, Brother Cosgrove, and we started at the same time. A male and a female, the exact same kind of job. Did we pay them the same thing, or did we say no because she's a female? This is 2020. What is it, 2020? 2020, whatever, 19. Thank you, John, 18. But the key is this, it's time for us to get past that. To tell you the truth about it, I'm gonna say something that you should never say. Women's probably can do the job better than a man anyway. So this is 2018. When are we gonna wake up? If they can do the job, pay them what they deserve. The same thing. I'm gonna vote this bill, you know that.
Thank you.
Thank you,
Mr.
Senator
Chairman.
Sproul. Senator Norman.
I would say to the center, I'm awake, and I move to report and re-refer to the Committee on Finance.
Mr. Chairman, before you do anything, I would just ask, there are a number of people who have come in support of this bill that did not speak. If you could just ask them to stand.
Oh, I'm sorry, yeah. If you are in support of this bill, please stand. I think I know where you're at, but judging by your reaction. Okay, thank you all very much. And thanks for coming up and Karen and expressing your views on the issue. It's been moved and seconded that the bill be reported and re-referred to the Committee on Finance. Clerk, open the rolls. Close the rolls.
15 ayes, 0 nays.
Thank you, Senator Wexton. Senator Wexton, you have another bill for us today.
I do. I hope you like this one too, Mr. Chairman. This is Senate Bill 421, paid medical leave, or as I like to call it, Virginia's healthier and more productive workforce legislation. Today in Virginia, almost 1.5 million workers don't have paid medical leave of any kind. Everyone gets sick at one time or another, as we have noticed over the past week and a half here in the General Assembly, but workers without paid medical days are left a difficult choice. They either go to work sick or send a sick child to school or daycare, or stay home and miss getting any sort of pay. The burden falls disproportionately on women, especially single moms, who make up a larger percentage of the hourly workforce and a higher percentage of primary caregivers to preschool and school-age children. Paid medical days are good business, too. You don't want employees coming to work and spreading illness among their fellow employees. Employees who don't have paid medical leave are more than twice as likely as those who do have paid medical leave to seek ER care because they can't take time off during regular business hours for doctor's visits. As we've been hearing many, many times over the past years, ERs are the least efficient and most expensive way of providing primary care, and driving people to seek medical care at ERs drives up medical costs for all of us. Senate Bill 421 would require employers with 50 or more full-time employees during the preceding year to provide paid medical leave to employees who work an average of at least 18 hours per week during each week of their pay period. Employees wouldn't be eligible until they've been employed by their employer for at least 90 days. Any accrued leave is forfeited upon separation or termination from employment for any reason, and they would accrue 1 hour per 50 hours worked in 2019, 1 hour per 30 hours worked in 2019 and beyond, for a maximum of 72 hours of accrued medical leave. Employees would also have to provide reasonable notice of their intent to use the medical leave whenever possible, and to use it in a manner that doesn't unduly disrupt employer operations. It provides flexibility to employers. After getting notice, they have the discretion to offer employees make-up hours in lieu of taking medical leave, and the employees can't reasonably refuse to take those rescheduled hours. And if the employer already gives this benefit at a higher rate or at an equal or higher rate, obviously this section would not apply to them. So I hope it is the will of the committee to report the bill.
Are there any questions for the patron? Seeing none, I see folks coming up. Yes, sir.
The governor also supports Senate Bill 421 for the reasons the senator stated.
Thank you.
Thank you.
Others who wish to speak in favor?
So my name is Charles Carter. I have had to work to take care of my wife when she got sick. I had to quit my job. I had to live off of our life savings because we had no one to give us any help. Receiving what this bill would do will help a lot of people who have to leave their jobs to take care of loved ones, or leave their jobs because they are ill. It would help save their homes, because I almost lost mine. We lost everything that we had, cars, homes, everything we'd worked all our lives for. This bill would make a major impact on the lives of the people within your district, the people that put you in office, to do the right thing for them. Getting this bill passed would be a major step in the right direction to help the people in Virginia. Sir, thank you.
Thank you. Yes, ma'am. And Senator Weston, if you could ask the folks to move through. I don't want to put you on a 5-minute clock, but be brief and let us know. Thank you for coming.
Okay, good afternoon. As a Virginian, our family depends on us to make ends meet, both at home and at work. Our employers depend on us. They need policies to reflect the 21st century dynamics and help balance it all. This is why Virginia should make sure every worker has access for paid family leave in case of a new child or serious illness of a family member or of their own health issues. Many home health care workers do not have paid leave, and they have to work if they get sick, which is a danger to your family members and mine. So we're asking you to support this bill. Thank you.
Thank you.
Hi, Mr. Chairman, members of the committee. I'm Thomasine Wilson. I'm a home care worker, and I have to be certified by the state to do the work that I do. And for one thing, Virginia Virginia population is aging and the need for caregiving is growing. The share of the population of about 65 that's and older will grow from 1 in 7 in 2015 to nearly 1 in 5 in 2030 in Virginia. Further, 35.6% of Medicare enrollees aged 65 plus have at least 4 chronic illnesses. And anyone who works hard in Virginia and be able to raise and care for a family with dignity, we should be able to do that. And say, but too many workers don't see their hard work honored with the ability to take paid time off to welcome a new child or to care for a sick family member or take care of their own health emergency. So I ask that you pass this bill. Thank you.
Thank you.
Mr. Chairman, Lucretia Fargo from the Virginia Interfaith Center, and we do support this bill.
Thank you.
Mr. Chairman, Senators, I'm Charles Summers, Presbyterian pastor and member of the Presbytery of the James Public Policy Group. We support this bill.
Thank you so much.
Thank you. Anna Scholl with Progress Virginia, and we also support this bill.
Thank you.
Yelena Verchena from NARAL Pro-Choice Virginia, and as the daughter of a mom who has multiple sclerosis, we do support this bill.
Thank you.
And I support this bill.
Jennifer Allen, Planned Parenthood Advocates of Virginia. I strongly support this bill.
Thank you so much.
Margie Del Castillo with the Virginia Latina Advocacy Network and also representing the Women's Equality Coalition. We support SB 421.
Thank you so much.
Julia Newton, SCIU Virginia 512, and we support this bill. Thank you.
Thank you. Are there those opposed to the bill?
Mr. Chairman, members of the committee, Ryan Dunn with the Virginia Chamber of Commerce. We would say most of our employers offer some PTO or other opportunities in this space. We did a survey of and had our economists look at the cost of what this one bill would have on the private employers in Virginia over 50, which is all this applies to. We're looking at $1.4 billion removed from the private sector. So requiring employers to provide paid medical leave with these certifications and the certifications with posting notices, additional record keeping, investigations that can come from the state, civil penalties to follow. Simply put, they do not protect an employer from abusive use of this leave. The employer with this bill would have no ability to simply question whether it is appropriate leave under this law. It's going to drive employers, quite simply, to cut back on PTO, on vacation, and on sick leave, or revert back to a simple sick leave. So, and we'd also just ask if this was simply good for all employers over 50, I'm not sure why it doesn't apply to those with collective bargaining agreements as well. So, thank you.
Thank you.
Mr. Chairman, members of the committee, Nicole Riley with the National Federation of Independent Business. And according to a survey that we had Mason-Dixon polling research conduct for us, more than 70% of small businesses offer paid time off to their employees, but most don't divide it up between vacation days, sick days, and family leave. Broadly written mandates typically are difficult for them to meet. And we feel that bills such as this really restrict their flexibility in being able to provide the type of benefits that fit their business and work for them and their employees. Thank you.
Mr. Chairman, members of the committee, Kate Baker with the Virginia Retail Federation. Many of our members do offer paid sick leave, and we feel like this is going to restrict them.
Thank you. Any others? Senator Wexton, I just have one question for you. I'm drawing your attention to line 19 and 20. You say employer does not include any state, local, or regional government agency or institution. Why would we impose on private businesses that we're not willing to impose on our own selves?
Mr. Chairman, I believe that's because it's just a reference to another, how employer is defined in the code.
No, I would say this, Senator Weskin, I don't believe that's the case at all. I think we're exempting state and local governments, and it's been the longstanding policy of this committee when it comes to health insurance that we will not pass a mandated benefit on private companies that we're not willing to pass a mandated benefit in our own state employees' health insurance plans. And I, for one, and I can't speak for the rest of the committee, but I, for one, cannot support anything that we're not willing to impose on our own government and our own employees. And as an employer, if we feel it's important enough that private businesses ought to provide it, then we feel important enough that we ought to provide it as a government also. And we're exempting government from that. And I, for one, cannot support anything that would exempt government and impose a harder restrictions on our private employers as opposed to the government. And that's what this bill does. It lays out a special pattern. Not only that, but we also exempt collective bargaining. And I don't understand why we treat those businesses that are union any different than those that are not union in this state. And do you have a rationale explanation why we don't impose that on collective bargaining agreements?
Well, Mr. Chairman, I would be perfectly happy to strike the remainder of line 19, starting with, quote, employer does not include through line 20 from the bill. And
Okay, it's been moved and seconded that we strike on line 19, beginning with employer, and the balance of line 19 and all of 20. It's been moved and seconded. All those in favor say aye.
Aye.
Any opposed? Okay, that line is stricken.
Mr. Chairman.
Yes.
Right.
Senator Cosgrove.
And I'm sorry, Mr.
Yeah,
Chairman.
just a second. Senator Cosgrove had some. Senator Cosgrove?
I'll defer.
Okay, Senator Watkins, I'm sorry.
Answering your question about the collective bargaining agreement, I'm not aware of a single collective bargaining agreement that doesn't meet these minimum standards. They far exceed the standards that are set out in this bill.
Okay.
No.
You make the motion. Senator Cosgrove.
Thank you. Mr. Chairman, this bill is actually pretty dangerous. And here's the reason why. You know, when Obamacare was given to us, basically the number of full-time employees in this country dropped drastically. Because if you worked over 38 hours, you had to have certain benefits and medical leave. The same thing is going to happen here. If you have employers that have 50 or more people, and they are forced to give their full-time employees after 1 week of paid sick leave. Now, we're not talking about personal time off, we're talking about sick leave. And after 2 years, almost 2 weeks, actually 70 hours of sick leave, you're going to have a lot of employers that are going to say, you know what? We're going to keep our folks at 38 hours. They're not going to get any benefits. And it's a real problem. Now, there are a lot of companies now that basically have just PTO, personal time off. And you can use that for vacation, or you can use it for sick leave. But if we pass this bill, we take that whole company structure and we say, you know, here in Virginia, you have to play by these rules, whether, you know, you have a liberal policy or not. Mr. Chairman, I think this is a bill whose time is just not here.
Okay, thank you. Any others? Committee operates by motion.
Move to PBI.
Yep.
Sorry.
It's been moved and seconded that the bill be reported and re-referred to the Committee on Finance. Any discussion? Hearing none, clerk will open the rolls.
Oops.
Okay. Clerk, report the bills.
4 ayes, 11 nays.
Okay, that bill fails to report and re-refer to Finance. Been moved and seconded that Senate Bill 421 be passed by indefinitely. Clerk, open the rolls. Close the rolls.
11 ayes, 4 nays.
Bill fails pass. Thank you, Senator
Thank you,
Wexler.
Mr. Chairman.
Okay. I believe Senator Dance and Senator Stewart both got to get out of here. So Senator Stewart said it was real quick, Senator Stewart and then Senator Dance. I'm sorry, they get you, and you'll be after these two each have quick bills and they got to run. So. Senator Stewart.
Thank you, Mr.
Promise
Chairman.
to be quick.
Senate Bill 260. Mr. Chairman, Section 6.2-862 currently requires that bank directors own a portion of bank stock, and the stock can be held in a revocable trust as long as that director is the sole trustee. What this bill does is it allows that director to hold that stock in a revocable trust as long, with a co-trustee, as long as the director that contributes the stock is a co-trustee and retains absolute power to revoke the qualifying stock, and therefore that director has the control over the stock. Not a big deal, but that's all the bill does.
Are there questions for the patron?
Mr. Chairman.
Senator Stanley.
How does this affect credit unions?
I don't think I can't say that. Do they have that requirement? I think this just applies to bank directors.
Okay. Is there anyone opposed to this bill? Seeing none, the committee operates by motion. It's been moved and seconded that bill be reported. Clerk, open the rolls.
Won't let me vote.
Close the roll.
Thank you.
15 ayes, 0 nays.
Okay, thank you, Senator Stewart. Senator Dance. Senator Dance, you have Senate Bill 246.
Yes, sir, Mr. Chair.
Go ahead.
I introduced this bill on behalf of the State Corporation Commission. It amends the agent's licensing chapter of the insurance title to remove an exemption from examination requirements for individuals who have been awarded a chartered property and casualty underwriter or a chartered life underwriter designation. The bill includes clarifying amendments to the State Corporation Commission's agent's licensing chapter. The only substantive amendment will remove an exemption from examination requirement from individuals who have been awarded certain insurance designations. The exemption has rarely been used by licensing candidates, and removing the requirement will get Virginia closer to the licensing requirements in other states, promoting greater uniformity across. In addition to this exemption requirement, there are 2 technical corrections to Chapter 18 that also deal with the licensing requirements. First is the additional terms are added to clarify who can be considered a designated licensed producer for an insurance agency. And 2, it corrects the omission of resident public adjuster entities from the list of entities subject to bond requirements for all types of public adjusters, including resident public adjusters, non-resident public adjusters, and non-resident public adjusters entities. Now, Dan Beavers from the State Corporation Commission is here to speak to any issues you might have in regards to these amendments they're requesting.
Thank you, Senator Dance. Are there questions for Senator Dance? I assume since the commission drafted this that they're very comfortable with it? Okay. Is there anyone opposed to this legislation? Okay, committee operates by motion. Been moved and seconded that the bill be reported. Senate Bill 246. Clerk, open the rolls. Close the rolls.
14 ayes, 0 nays, 1 abstention.
Okay, that bill's been reported. Thank you, Senator
Thank you.
Dance. Okay, next on my list is Senator Surville.
Thank you, sir. May I have another? I have a substitute.
Okay. I hear a motion on a substitute. Been moved and seconded that the substitute 626 be adopted. All those in favor say aye. Any opposed? Okay, the bill's before us. Senator Surville.
Mr. Chairman, members of the committee, there's this bill relates to an incident which is also inspired Senator Saslaw's bill, which is also before you today. Relates to a situation that happened up in Northern Virginia involving a guy named Joaquin Rams. Mr. Rams went out and purchased 3 insurance policies for his 2-month-old child, totaling $550,000, and then he murdered his child at 15 months. About 12 months later, he was convicted and tried to obtain that $550,000, and it's pretty clear from the case that he sort of contemplated getting those policies with the intent of killing his infant from the day he got them. The legislation you have in front of you says that no life insurer can obtain or can issue a policy on a child without the consent of both of the child's parents, and there's some exceptions for that when a parent's identity is unknown, when the parent is separated from legal custody, or if a parent's rights have been terminated. There's another amendment that I added in subsection C, which allows an electronic signature on these kinds of policies, which was requested by one of the insurers I've been working with. So this substitute reflects input from, I think, USAA and Genworth, I believe, who had some requested changes. The American Life Insurance Institute's also monitoring the bill, and they have some more suggestions maybe further in the process. But right now, I think people are kind of in agreement with the language. Senator Saslaw's bill puts a cap on the amount of the policy and has some other age restrictions in it. And I don't know whether the committee would want to roll these together or deal with them separately, but it's two different approaches to the same problem, which is getting really large life insurance policies on really young kids, which is something that I think this case proves we should have a little bit more restriction on.
Okay. Other questions for Senator Serval?
Yes, Mr. Chairman.
Senator McDougal.
Senator Serval, so if I had a spouse, or let's say you're divorced or separated, and one spouse wants to get an insurance policy for the child, like the one I have for Reagan, which is $100,000, and it's a whole life policy, so it's actually an equity vehicle for her for the future, and I decide I want to do that, but you're in a bad domestic dispute with your spouse, then you can't get that without their consent.
If you have
If we pass this.
I believe the way, if you look on line 21 and 22, if you have sole legal custody, you could get it. But if you have joint legal custody, it would require the consent of your spouse, I think is the answer to that.
So Serval, you do a lot more domestic work than I do. Is most court orders now have joint legal custody?
Most do.
So if you and your spouse did not agree, you could not get that vehicle for your child under this statute.
A life insurance vehicle, yes, you could get something else, but not life insurance. That's right. And that's kind of what happened in this case. He went out and he told the life insurance companies that the mother was dead. He also lied about his assets and his income. But yes, I think that's mostly right.
Mr. Chairman?
Okay, any other questions? Senator Sproul.
Then what happened if they're just separated? A lot of times, spouses are separated, they're not divorced, but they're separated for years and years, and the kids with one or the other. Are they allowed to get insurance on their kid?
Under this bill, the way it's written right now, and these are the things that we've been talking about trying to address as this moves through the process. If you certify the parent's identity is unknown or the whereabouts of the parent are unknown, you would only need one parent consent. But if they're just separated and there's no court order or anything, and you know where they are, you would need both signatures.
All right, Mr. Chairman, second question.
Senator Sproul.
And what happens if it's a known fact, which is happening, especially a lot of young folks now, when there's one parent that's raised the kid and, a mistake was made, and the young lady got the baby, and this mistake was made, they didn't get married, and she's raising the kid, and the guy's going about his business, and everybody know about it. She want to get some insurance. So because there's no good guy ain't doing his responsibility, I want to get some insurance, as the spouse want to get some insurance on this kid. I know the guy's around the corner somewhere, but we made a mistake when he was young. And the girl's raising the baby by herself. He ain't doing a darn thing for the baby. So you want to get insurance from the guy. So you mean to tell me this guy who ain't no good at all, ain't paid no child support, the young lady's raising the baby all by herself, she want to get some insurance. You got to go to this no guy who is no good at all to get some permission for him to get some insurance from the baby?
Potentially. If that mother has a court order giving her sole custody, then she could get it without that person's signature. Or, I believe the way this is written on line 21, if she were to certify satisfactory to the insurance company that a parent's identity or their whereabouts are unknown, they don't know where the father is, then they would not need to get that second signature.
Thank you.
Senator Sproul, does that complete
sir.
your
Thank you.
questions?
Yes,
Okay.
sir.
All right. Any other questions?
Mr. Chairman?
Senator McDougal.
If I understand, the problem was somebody took out insurance policies that then harmed their child.
Correct.
And then they benefited from it. Wouldn't it be they didn't benefit?
They tried to, and then all got hung up pending the murder trial for a court to say that he actually murdered the child. There was a dispute about whether or not he murdered the child or whether it was an accidental drowning, but the judge eventually found it was a murder.
Well, Mr. Chairman, isn't it the
Senator
better course to try to make sure that we do already have statutes that you can't benefit from that insurance policy, or to tackle it from that direction instead of from prohibiting a parent from being able to write it? I think what Senator Sproul was articulating, I think happens more often where parents, they might know where they are, but they might not agree, and one parent wants to do the right thing for their child, and most of these are actually going to be a benefit for the child to have a whole life policy. Why wouldn't we want to give one parent to give that benefit to the child, and work on making sure that somebody cannot wrongfully obtain the resources if they're a bad actor?
Well, I would say I think what you're referring to is the Slayer statute. And the Slayer statute would not come into effect in this situation because there would be no other person to benefit from the policy other than this person. And I've been in situations, legal situations, where, for example, I represented a 19-year-old woman whose mother was murdered by her second husband. And he then tried to get her $200,000 of life insurance to pay for his legal bills. He was convicted of manslaughter, killing his wife, and the insurance company still wanted to pay him the money, even notwithstanding our Slayer statute. And if this provision were in Virginia law and an insurance company were lied to in connection with the process, as happened in this case, it would give the insurance company a basis not to pay out. But sometimes, for example, in this Rams situation, there wouldn't be a person to bring that Slayer statute situation because the only beneficiary of the policy was the defendant. And so sometimes the insurance companies don't want to fight these things. They just rather pay out and not deal with it. And this would prevent that. It would give them, an insurance company, a reason not to pay.
Okay. I think Senator Chafin had a question. Senator Chafin.
Actually, Mr. Chairman, I'd like to make just a little comment. I think that Senator Serval has some good ideas, and I supported some of them this morning, but I don't think this is one of them. I mean, I think we're going down the wrong path here. We have half the people are divorced, okay? Out of that half, a lot of them have very acrimonious relationships, and they are looking for things to disagree about, okay? They're looking for something to drive a wedge or to find some way that they can get leverage on their other spouse. And I think that putting a bilateral consent for the purchase of an insurance product is a significant barrier to the insurance industry for the citizens of the Commonwealth, and that's why I won't be supporting the bill. Okay.
Chairman?
Yeah, Senator Cosgrove.
Thank you, Mr. Chairman. One of the problems I have with this, I have a 9-month-old granddaughter, okay? If I wanted to set up a whole life policy for my granddaughter, I guess under this statute, I would have to have both of her parents' written consent to do that. Is that correct? All right. And question, further question, Mr. Chairman?
Senator Cosgrove.
If I had a granddaughter whose parents were separated under a less than happy circumstance, and wanted to do the same thing, under this, I really couldn't unless both of those parents agreed if they had, let's say, joint custody. Is that correct?
That's correct.
All right. Thank you, Mr. Chairman.
Okay. Any other questions for the patron? Are there those who wish to speak for the bill? Oh. How about are those against? I saw this young lady coming up. I thought maybe she wanted to speak, but those who wish to speak against the bill.
My name is Gordon Parker. I'm a resident of Virginia Beach, and I'm a 28-year life insurance professional here in our state. And this bill is a bad bill for a number of reasons you've both described. From a practical standpoint, it's very, very difficult to get a life insurance policy issued on anybody these days. This is, I remind myself of the Smolka case back in the early 80s. where a hotelier in Virginia Beach, the proceeds were never paid. They were paid to the kids. So in this example, I would tell you this is bad underwriting by the insurance companies, and they're the ones that should be doing a better job to verify the net worth and the need on the sale, not us legislating what that maximum should be or minimum should be.
Thank you very much. There's still more to come here, Senator Servo.
Mr. Chairman, Reggie Jones, representing American Council of Life Insurance. We've struggled with this because obviously his set of facts is difficult to deal with. We've tried to work on some ideas about ways to try to come up with all the protections we thought were necessary, and I don't think we'll be able to come up with all of those, but some have come up since the list that we've given him. Sometimes bad facts make bad law, and it's just difficult to deal with. Certainly in the circumstance he's talking about, the person did not recover. If someone's convicted, the insurance company is not going to pay out. Now, I think his concern is they may pay before they realize that the person is being charged with murder. But it's just difficult. We've tried to figure out a way to work through this with Senator Servo. I'm not sure we can cover all the circumstances that are necessary. And I think what was raised by Senator Spruill and Senator McDougal certainly are issues that we are struggling with, where you have parties who parents who are separated, estranged, not willing to cooperate. How do you have one party put insurance on the life of the individual? So we have concerns. We're trying to figure out a way to work it out. I don't know whether we can or not.
Thank you. Senator Servo, we've had an at-length discussion. I think we're ready to vote.
Yep.
Been moved and seconded that Senate Bill 626 be passed by indefinitely. Clerk, open the rolls. Close the roll.
12 ayes, 3 nays.
Thank you, Senator Servo.
Thank you. Good luck to Senator Sasslaw on his.
Okay. Next on my list is Senator Vogel.
Thank you, Mr. Chair and members of the committee. I have Senate Bill 593, and I have a line amendment.
Okay.
Alex.
Clerk will pay attention to Senate Bill 593.
Okay.
Mr. Chairman, there are two amendments that do the same thing. On page 1, line 21 of the bill, after 2019, strike of any age and insert from age 2 years through age 18 years.
Okay.
And Mr. Chairman, the same change is made on page 2, line 96, after individuals, strike of any age and insert from age 2 years through age 18 years.
Okay. Senator Vogel.
Okay, thank you, Mr. Chair.
Well, why don't you explain the bill, and that might make the amendments
This
more.
is not unfamiliar to, I believe, most members of this committee, so I will keep it very brief. As you all know, in 2011, we became the 26th state to enact autism insurance reform. And what we have now is autism coverage through age 10. What this bill would do is take it to age 18. Previously, it said any age, and I've amended it to say 18 in hopes that it would help the bill. Just to hit a couple of quick points for you, there are about 10,000 Virginians with autism who need coverage and who are not covered simply because of their age. And this arbitrary age limit has created real hardship for many families. And as somebody who spent a whole lot of time traveling all over the Commonwealth of Virginia, I cannot tell you how many times this issue came up and how many families have been affected. There are not any other health conditions where there are limits imposed based on age. That's, I think, relevant. Also, it's relevant that many children, I think the average age of diagnosis is around 7. So when you're talking about having the opportunity for early intervention, you're talking about a time frame when you're just about to run out for options for coverage and for options for treatment. Early intervention, we know, makes a big difference. It has a huge impact. And so a modest investment when a child is young and needs that intervention can make the difference between them being highly productive members of society who can work and can engage or not. And so with that, I will step aside and let a few people who would like to speak to the committee speak. Thank you.
Thank you. Are there questions for Senator Vogel? Yes, ma'am.
Thank you, Senator Vogel. Mr. Chairman, members of the committee, my name is Teresa Champion. I'm with the Virginia Autism Project and also with Autism Speaks. And when we started this about 10 years ago, you all probably don't recognize me because I was much younger and much more energetic then. But here I am again today, and I am asking you to lift this age cap. As the senator stated, no other health care diagnosis is cut off at a certain age for coverage. I don't think we're talking whether this is a good policy issue or not. I think we've established that. This has been going on for a while now in Virginia. We've got some good data on that. Another speaker will address that. This is medically necessary care, ladies and gentlemen, and we passed a licensure bill to make sure that it's safe care, and we wanted to make sure it's quality care given by BCBAs. And this is evidence-based approaches. It's not just ABA. It's not just what we're talking about ABA. It is speech, OT, psych, and it is all prescribed by medical professionals. Thank you.
Thank you. Yes, ma'am.
Mr. Chairman, members of the committee, thank you so much. I'm Judith Ursetti, and I'm Director of State Government Affairs at Autism Speaks. I'm also a certified public accountant. Please don't hold that against me, but my job here today is to talk to you quickly about the fiscal impact of this legislation. We all know many of you have worked on this legislation with us for years. I've been working on this for about 10 years too here in Virginia. And we've been very thoughtful and have evaluated this legislation. And there has been concern about the fiscal impact, about the rising cost of health insurance premiums and its effect on employers. So we proceeded carefully. When we first passed the bill, it was capped at age 6 because we wanted to provide that intensive early intervention. That is the most expensive component of this legislation, is that heavy-duty intensive early intervention. We covered to age 6, then a few years later we went back and were able to move that cap up to age 10. We've been very thoughtful and incremental. And as you all also are aware, every year the State Corporation Commission pulls together a report about the impact of all of the health insurance mandates on health insurance premiums here in the Commonwealth. And we know that the most recent numbers for that, for autism, for the coverage that you've worked on, that we've worked on, impacts health insurance premiums about $3.50 per year, and that comes in at about 29 cents per member per month. So far less than projected, and please let me remind you respectfully that that's the most expensive component. So all we're asking now is that a teenager who might be hitting puberty, who has autism and starts having challenging behaviors or seizures, their health insurance coverage will cover the evidence-based treatment their doctor prescribes. It makes good sense. You don't want those teenagers to be residentially placed. You don't want to increase the burden on the Commonwealth and on their families, on their siblings. So I would ask you today from a fiscal perspective, really to acknowledge the minimal premium impact that this intensive intervention has cost, and just open the door to those people who so desperately need it once they're past the age of 10. Thank you so much.
Mr. Chairman, members of the committee, my name is Mark Lobel, Sr. I'm a proud grandparent of a 14-year-old boy who has autism. We've been up here for about 10 years trying to get insurance coverage for our kids. Now, it's been a long, long road, and we've made a little bit of progress, and for that we're grateful. But a child doesn't grow out of his autism at age 10 or age 11 or age 18. They've got it for life. So what we're asked in our original bill as it was written was to remove the cap. Fiscal impact to the state was $96,000. Cost per month for an insurance provider, 29 cents. And that's Virginia state data on what we've covered to date. So I respectfully ask all of you members of the committee to support us in this endeavor. These kids need these services. You know, they need some therapy. Some of them need them at age 6. Some of them need them at age 12. Some of them need them at age 18. But trust me, as a guy that lives with it every day, 24 hours a day, they need them. Your vote would be appreciated. Thank you.
Thank you, Mr. LaBelle. Yes, ma'am.
Mr. Chairman, members of the committee, Ashley Wright representing the Arc of Virginia. We thank Senator Vogel very much for bringing this legislation before you, and we support this.
Oh, thank you. Okay, are there those opposed to the bill?
Mr. Chairman, I'm Doug Gray. I'm Executive Director of the Virginia Association of Health Plans. We have not supported the mandate on applied behavioral analysis throughout the process. One of the things that I think is important for you to understand is that we've always had a mandate for medical services for autism because it's a behavioral health condition in the statute. There is a dollar cap on applied behavioral analysis because it's not a medical service. And that's just a fact. What it is a behavioral modification intervention that seeks to promote certain positive behaviors through training. That's what it is, and that's what it does. A $35,000 cap has been in place. The age cap has moved over the years. The challenge with this particular proposal that's in front of you is the question of evidence of effectiveness after age 10. There aren't studies in great number. There's a lot of studies, but there aren't studies that show effectiveness in adolescence for ABA. And so taking the age cap off altogether is not a great idea. 18 is certainly better than taking it off altogether. The bottom line is that there is a fiscal impact, and that's why the fiscal impact on the bill shows a $238,000 impact per year for the state. And as Senator Wagner, Mr. Chairman, has reminded, if you're going to do something, you have to apply it to the Commonwealth as well. So yes, we're having problems in the insurance market. Yes, premiums are under a lot of stress. Yes, the expense is growing. Those things are all facts. And adding one more thing is one more thing, along with many other things that have been added. And I will appear before you many times in the next week and a half with other items that folks would like to add.
Mr. Chairman,
Senator Sasslaw.
I was pointing out to Senator Norman that these mandated benefits aren't what's driving up insurance costs. It's the conduct of the people who are buying these insurance policies. They smoke. They're unable to push themselves away from the all-you-can-eat buffets. I mean, I could go on and on and on. That's what's driving the cost of health insurance, not providing, benefits such as this. And whether it's, if it's $3.50 a year, and even if you take your numbers instead of theirs, so it's $9 to $10 more a year, if that, my math's not too good, per person. That's certainly something we can afford. You and I are fortunate. We didn't have children that had this. But to these people, and in a lot of cases, they do see improvement with their children who are being treated. And yet this is one of the rarities that we have in the code where, you can cut it off after age 10. She's put the cap back at 18. I just don't see where we totally disrupt, medical care in Virginia by allowing this bill to move forward.
Those questions.
Isn't that right?
Mr. Chairman, I was waiting for the question.
Senator Castro.
Mr. Chairman, I guess the question I have, I'm looking at the fiscal impact statement for the bill as it was presented to age 10. As we move it to age 18, what happens to the fiscal impact statement? Do we have an updated one?
Senator Cosgrove, I don't know that we have that. The fiscal impact was written for,
It's less now.
it was written for a lifetime, and now we're restricting it back to 18 based on the expenditures to date from 0 to 10 now. That have been very minimal in terms of the total impact, the total cost. So anyway, Senator Gray, I got just one more question for you. Not Senator Gray, Mr. Gray. You want to run for office? That would be my first question. Okay. All right. Well, that one's off the case. Then my next question to you is, what would do you more good, not passing this bill or doing away with certificate of public need?
Mr. Chairman, what a wonderful question.
Well, you got an answer for me?
Actually, Mr. Chairman, we favor reforms to certificate of need. As an association, that's a position we've taken. So the short answer is we would favor that. Look, I've already said that marginally it's better to go to 18 than to have an unlimited cap. But I just want to make sure you all understand there's a reason why this is different. This is not a normal, everyday medical service. It's a different item. And look, the history of it is that we cover it and that it does have an effect and a positive impact up to age 10. The question is whether there are studies that support that impact after age 10, and that's why we're not supportive. So that's the bottom line.
Mr. Gray, you know, I'm very supportive of it, but I think we're going to find out just how effective it
Sure.
is up to age 18. But
Okay.
I'll wait to see how the committee feels about it also. So,
Thank you, Mr. Chairman.
Senator Vogel, we do have a letter from Finance that if we are in favor of this bill, that needs to be referred to Finance just to take care of the funding on the state
Right.
employee part, which I suspect
and
is
if
not
I'm-
going to be great.
If I may, Mr. Chairman, just to respond
Senator
to
Vogel.
Senator Cosgrove's question about the fiscal impact. The impact statement that you have before you now is with no cap. It should be dramatically different at age 18. So my hope was to bring something that might be a little bit of a compromise, yeah, and then it would lower the fiscal impact.
Mr. Chairman, I would move the report and refer.
Excuse me, we haven't
I guess I
adopted the
would.
amendments yet to reduce it down to that age 18. So it's been moved and seconded that the amendments reducing the age from, lifetime down to 18. All those in favor say aye. Aye. Any opposed? Okay, those amendments are adopted. Now, a motion on the bill. It's been moved and seconded that Senate Bill 593, as amended, be reported and re-referred to the Committee on Finance. Clerk, open the rolls.
Thank you, Mr. Chair and members of the committee.
Okay, thank you.
15
Thanks.
ayes, 0 nays.
Thank you. Okay, next on the list, Senator Favola. You're reading my mind.
Thank you, Mr. Chairman. I won't take long. I'm only presenting one bill, Senate Bill 41. And this is probably the narrowest bill you've seen today on paid family leave. What this bill says is for employers who are already providing sick leave, and it defines employers to me, those who are employing 25 or more employees, and an employee works more than 30 hours a week. Under that context, if the employer is already providing sick leave, the employer needs to allow an employee to use the sick leave to care for an immediate family member. And that's really the essence of the bill. This is modeled after a bill that passed in Georgia, and I learned about this at the Southern Legislative Conference. I just thought you should know that sometimes you pick up good ideas when you go to these conferences in the summer. So I have a few people who are in support of the bill. This does not have a cost impact because state employees, I believe, do earn sick leave. But this would apply to I don't differentiate between public and private employers.
Thank you. If we could hear from the speakers again briefly, please. We've heard from you once, so
Yes, sir. Anna Scholl again with Progress Virginia, and we do support this legislation.
thank you, Anna.
Mr. Chair, Jennifer Allen with Planned Parenthood Advocates of Virginia, and we support this bill as well.
Thank you, Jennifer.
Delina Verchena, Mayor of Pro-Choice Virginia, and we support this legislation.
Thank you.
Sir, as a former home health care worker, this is something that is desperately needed. You have people that's working all those hours. They get sick. Who's going to take care of you or your family members when they're sick? How are they going to feed their families? Thank you.
Thank you.
I'm Thomasine Wilson. I'm a home care worker, and I provide care for senior citizens and an ever-aging population of seniors. And I've been doing this a very long time. And I'm helping people to live longer, and I would like to be able to live long and strong myself. So I'm asking that you pass this bill.
Thank you.
Julia Newton with SCIU Virginia 512. As a personal care assistant, I have went to work sick a lot of days, and I have exposed the people that I work with to whatever that was going on with me. So I support this bill. Thank you.
Thank you.
I'm Maria Ortiz with the Virginia Latina Advocacy Network and the Women's Equality Coalition. I'll be reading a brief testimony from a full-time student and single mother of 2 young children. And Lorena, and she writes, I deserve to raise and care for my family with dignity. Instead, I fear that even after working so hard to pursue a degree in the STEM field, I will continue to struggle as a single parent. This bill would reduce the stress on my family, and we will no longer worry about the impact on my employment from missing work. And with the proper system in place, I can be both an active and caring parent while pursuing my career and doing what I love. This bill will allow me to do that. Thank you for your
Thank you
time.
very much. Senator Favola, is that complete? I think there's some opposition to it, so let's hear from those folks.
Mr. Chairman, I had a question.
Senator McDougal.
Senator Favola, am I reading this correct? If a company that's in the population brackets or the employee brackets decides not to offer sick leave, just offers paid time off, and that's a set block per year, then they would not fall under this provision? So you could have a company of 26 employees that offers 15 days of paid time off every year, and then they would not be required to follow this provision.
I mean, I guess I'll have to ask counsel. This is worded around sick leave. I don't know where paid time off, where that might be in the code, or if it's defined as the same thing. So I will defer to the general counsel on that question.
Mr. Chairman, the bill does not address paid time off. It's drawn only to sick leave, which is defined in lines 23 through 25 as time away from work that's provided by an employer to his employee for the purpose of permitting the employee to be absent from work in the event of the employee's own incapacity, illness, or injury for which he's paid. There's no reference in there to any other permitted type of use of that leave.
Okay. Senator Sproul.
Again, sir, my question, so if I got sick leave, so if I want to use that sick leave to take care of someone else, that's what they're saying, that I can use that sick leave for somebody else?
That's what the bill says. The bill says that if you're an employer that provides sick leave to your employees, the employee would be able to use that time to care for family members who are ill.
All right. Second, then a question to you. If
Yes.
let's, Mr. Chairman, I'm sorry. Mr. Chairman?
Yeah.
Second question. The second question, let's suppose that would happen and you use the time for a loved one, and then, but you're still employed, and then while you're working that same year, you happen to get sick. What happens to you?
I guess it would depend on Mr. Chairman and Senator Sproul, it would depend on the policies of the employer, but it says nothing in this section on line 32 shall be construed to require an employer to provide sick leave or to allow an employee to use more than 5 days of earned sick leave per calendar year. So it would depend, I believe, on the policies that the employer currently has. Whatever policies the employer has that govern sick leave would also govern the ability of an employee to use that sick leave to care for another family member.
Mr. Chairman?
Senator Sproul.
Then let's suppose you, I've been with the company, just started this company 1 year. And 1 year, most companies give you a week, sometimes 1 year.
Right.
So during that 1 year time, my parent gets sick and I use it for my parent. And then all of a sudden, 2 weeks later, I get the flu. So the company time say one week. It's this company time for a year. I then use it to help a loved one. And now 2 weeks later, I get sick. And you only have 1 year. So what do I do for myself?
Mr. Chairman, Senator Sproul, if you have exhausted the sick leave that you've accumulated, I guess you'd have to have a conversation with your employer. But I will ask General Counsel if you have a more enlightened answer to that question.
Well, Mr. Chairman,
Okay.
the bill doesn't address the situation, but under the Federal Family Medical Leave Act, the person may be entitled to unpaid sick leave. The way sick leave is defined in this bill, it's paid sick leave.
That's correct.
Senator Favola, the section regarding employee and employer taxes assessed, could you go into that in a little bit of detail for me? That's lines 162 through 181. It talks to.
162, my bill is, this is Senate Bill 41. My bill ends on line 40. Are you on the right bill?
All right.
I'm
sorry. I
You must be
apologize.
on a different bill.
I apologize.
Okay.
I got one of your wrong bills. Okay, that's the one you artfully struck. Are there other questions for the patron? Are those opposed to the bill?
Mr. Chairman, members of the committee, Nicole Riley with NFIB. The reasons are very much stated as stated before on Senator Wexton's bill. And in fact, this bill, because it deals very specifically with sick leave, I mean, you actually start getting into a situation where you really are restricting the flexibility of a small business owner to be able to address the types of leave that he or she wants to provide their employees. As I mentioned before, a lot of employers offer some type of paid leave. They just don't necessarily designate whether or not it's sick leave, whether or not it is paid vacation time. And this is here where you would actually now be codifying very specific specifications to how they would use sick leave. And for those reasons, we would oppose the bill. Thank you.
Mr. Chairman, members of the committee, Kate Baker on behalf of the Virginia Retail Federation. We believe this restricts our members, and many of them already offer this benefit.
Thank you.
Mr. Chairman, members of the committee, Ryan Dunn, Virginia Chamber of Commerce, also oppose the legislation. Don't want to see this type of language in the code. Rather have flexibility, and PTO will be adjusted accordingly should bills like this pass. And we hope that at least in this section, it's 50 employees and above. And we know from talking to our members, almost all of them allow this in the first place. But codifying it in the code takes it to the next level.
Thank you. Any other question? Okay, Senator Favola, I think we've heard it. We've heard a similar bill, although this is, as you said earlier, broad, narrower in nature.
This is narrower, yeah.
Okay, committee operates by motion. Been moved and substitute motion to Senate Bill 41. It's been seconded. Clerk, open the rolls. Close the rolls.
11 ayes, 3 nays, 1 abstention.
Senator Favola, the bill's been passed by indefinitely. Thank you.
Okay, I'll bring it back next year revised. Thank you.
Look forward to seeing you. Senator Suderline. Not here. Members' bills. Senator Sturtevant. You have 755.
755, yes. Thank you, Mr. Chairman. Senate Bill 755 is a bill regarding pension de-risking. And there is a substitute that I would move be adopted.
I hear a motion on the substitute. Been moved second to the substitute to Senate Bill 755 be adopted. All those in favor say aye.
Aye.
Any opposed? Okay, the bill's before us.
So, Mr. Chairman, members of the committee, as you know, for many years, large companies offered pensions to their employees to provide for retirement after their working years. More recently, as we all know, companies have moved towards 401ks to provide retirement rather than pensions because of the significant cost and liabilities that go along with pensions. Something that we have seen in more recent time is what's called pension de-risking. And this is where a company that had offered or offers a pension to its employees in order to get that liability off its books will sometimes just offer a lump sum payment to its former employees who are now retirees. That's one form of de-risking. The other form of de-risking that this bill seeks to address is the purchase of a large annuity that then provides monthly retirement benefits to employees in lieu of a pension. So the large company that offers a pension will go and purchase a huge annuity from an insurance company to provide those retirement benefits to its former employees. All of that is perfectly legal and good, and it's a way for these companies to get those risks off of their books. And you can debate the merits of it, but it's something that is done. What this bill seeks to address is, once the insurance companies are offering those annuities, they can still then go and sell those annuities to a third party, to another insurer. And at that point, there is no oversight to help ensure that the third-party purchaser of that annuity is fiscally sound and is solvent. And so what this bill seeks to do and does is to ensure that there is some level of oversight over the selling of those annuities to a third party, and it simply requires that the State Corporation Commission sign off on the sale of an annuity to a third party, confirming the fact that that third-party purchaser of the annuity is fiscally sound and solvent, so that we don't end up with a situation where, if, like we saw during the financial crisis, an insurance company fails, goes out of business, then we don't have, then you have a lot of retirees who have potentially lost their retirement as a result of that failure of that insurance company.
Are there questions for Senator Stewart?
And I have the constituent who brought this idea to me is here and has been sitting here for a couple of hours, and I know he'd like to
Definitely.
get up and speak
Yes,
very
sir.
briefly, if he may.
Thank you for your patience, sir.
Thank you.
I hope you found the meeting interesting so far.
I sure have. Mr. Chairman, members of the committee, I'm Dave Edmonds. I was a employee of Verizon Communications for 32 years. I've been retired for a little more than 25 years now. When I retired, I had the decision. I could accept a pension or I could take a lump sum. I chose the pension because that was being a little more traditional and a safer, rather than having to worry about the stock market and everything for the rest of my life. Well, for the first 20 years of my life, I thought I had made a good decision. 5 years ago, though, Verizon sold off all their pensions to Prudential Insurance Company without consent, and I was one of those 41,000 whose pensions were summarily transferred and converted into annuities. As the senator said, once a pension is converted into an insurance annuity, you lose all federal protections under ERISA and under the PBGC, the Pension Guarantee Corporation. So what happens then if an insurance company fails or becomes insolvent? Pensioners like myself are then dependent solely upon what protections exist in the state in which they are the resident. Verizon was the first company. There have been 20 companies since 2012 that have followed suit. We're talking billions of dollars and tens of thousands of retirees and pensioners affected. My purpose today is really to seek your help through this legislation in just restoring a couple of the protections we lost at the federal level. The subsequent transfers to prevent companies X, who it may be financially solvent, selling it off to company Y, who may be much less solvent, and put us more at risk. And the other one is protection against creditor claims. So that's our only plea here. We're not asking for any additional benefits. We're simply asking for restoration of a couple of those benefits that we lost. And I believe this is revenue neutral.
Thank you, sir.
very much.
And you certainly got Senator Spruill's attention. I noticed, talking about Verizon's retirement plan. He certainly, are there questions for the patron?
No, Mr. Chairman, I wouldn't speak on the bill, though, if I could. May I?
Yes, absolutely.
Listening to what the brother was saying, I took the bow, and I'm doing very well. But I'm trying to figure out why you blaming the company, because a company that got 42,000 people and it's for insurance-wise. So I'm trying to figure out, are you trying to get back at Verizon because you chose to take the monthly thing that gave you an option? You had the option to do what you want to do. He chose the wrong option, in my opinion. I chose the right option, and I'm doing well. So are you trying to punish Verizon because he chose the wrong option?
Mr. Chairman, not about punishing anybody, not about criticizing anybody. As I mentioned in my presentation, this is a de-risking process that is perfectly legal, and it's in a perfectly appropriate way for companies to go about getting these liabilities off their books. And this is just one instance where, through the purchase of annuities, that can provide a good, long, sustainable benefit to retirees. And those companies are doing that in the best interest. They have a fiduciary duty when they do this, to do it in the best interest of their employees. The concern, however, because at that stage you still have a lot of federal protections in place through ERISA, but what this seeks to address is farther down the line is if those annuities then get sold off to a third party after that initial purchase of the annuity by the employer from the insurance company, if there is then another sale down the road to another third party, this just seeks to make sure that that third party buyer is solvent and fiscally sound.
Mr. Chairman?
Senator Sproul.
Then what happened, let's take in my case, when I took the buyout and I had investors come in to do it for me the right way. What happened if the investors who were helping me to invest my money the right way, which I'm doing well, what happened when so many employees with Verizon who did not invest right and they lost all the money? What happened? I'm saying that what happened? Do they have the right to come here and say to them, to this body, I took the buyout instead of a month and pinch, I took the buyout, and there was some decisions were made wrong by my investors. Now I don't have a pension.
No, Mr. Chairman, no, this does not address, it does not address prior retirement decisions. It does not address anything related to buyouts. This is specifically with regard to annuities.
Thank you.
Any other questions? Anyone opposed? Committee operates by motion.
Move to report.
It's been moved and seconded that Senate Bill 755 be reported. Any more discussion? Clerk, open the rolls.
Mr. Chairman, I don't think I can vote on this because
Okay.
I don't think I can.
'Close the rolls.
13 ayes, 0 nays, 1 abstention.
Okay, that bill's reported. Thank you. Senator Chafin, I think you have some bills for us? All right.
Move approval. Move approval.
And then Senator Stanley, you have a bill? You have two, right after Chafin. And Senator Cosgrove has a bill.
Thank you, Mr. Chairman, members of the committee. Senate Bill 387. So all corporations, stock corporations in Virginia are required to file an annual report. And on that annual report, they're required to indicate the number of authorized share and also to itemize by class the types of shares that are on that the company has. What this bill would do is it would take away the requirement that annual report have to disclose the types or classes of shares, like common shares, preferred shares, et cetera. That's really all that this bill does. And this bill was brought to me by the State Corporation Commission. They're in a process of modernizing and bringing some things up to speed, and it's very infrequent that a request or that people are even looking for the itemization of the classes of the shares. And so they brought this to me.
The questions for the patron. Here it's done. I have a motion to report. It's been moved and seconded. Senate Bill 387 be reported. All those in favor say, clerk, open the rolls.
I can't vote for it here.
Okay. Close the rolls.
14 ayes, 0 nays.
Okay, that bill's reported. Is that
I believe
complete your
that's it.
docket, Senator Tate?
I think so.
Okay, all right. Senator Stanley. You have two bills today?
I do.
You do.
Why don't we take, if we can,
Take
Senate
them
Bill
in order.
779 first, if you don't mind.
779.
Mr. Chairman, members of the committee, Senate Bill 779 comes from a fellow colleague down the hall who will remain nameless, but her maiden name rhymes with Jolly. So she presented this bill, and we talked about it a little bit. And so what we're trying to do here is this bill seeks to avoid any kind of non-compete clause between employers and physicians. Look, and I pulled some case law to see this. You know, in Virginia, Mr. Chairman, and as a lawyer who has dealt with non-competes before, non-competes are enforced if they're limited in scope and basically in the size of territory to which they seek to prevent a former employer from working in an area where the employee might have information about their clients. There's also proprietary information as well. But what I've seen in some of the case law here is that states other than ours treat physician non-competes differently because there's a special public interest associated that is much different, and that is the freedom of the patient to choose who their doctor will be. I mean, think of it this way. If a doctor is employed by a certain physicians group, upon the termination of the contract, there's a non-compete clause. That physician has had certain patients, maybe you or me or anyone else, and that doctor now can't continue as my doctor based on the non-compete, based on what may be the length and scope detailed in that non-compete clause. So what I've seen is that courts have given great weight to the right of citizens to obtain treatment from the physician of their choice, concluding that the doctor-patient relationship trumps any interest that an employer might have in protecting its patient base. And so the AMA, the American Medical Association, has even concluded that non-compete agreements are unethical if they fail to make reasonable accommodation of patient's choice of physician. So in that kind of instance, when we think of traditional non-competes, let's say I make a special kind of, donut, and it might be proprietary information. I don't want someone taking my recipe and making that exact donut. Other ways are I may have a client list and a client base in a non-medical field, and I don't want someone that I hire going out and taking my client list, competing with me, and the only reason they have that is by virtue of working with me before. But this is different because we're talking about where patients are excluded from their choice of doctor based on a contractual relationship between that doctor and that doctor's practice. So that's the bill.
Okay, other questions for the patron?
Mr. Chairman,
Senator Cosgrove.
I wonder if Senator Stanley would be open to a friendly amendment. Can we strike lines 11 through 40 of this bill? Just curious.
I'm telling Senator Donovan on you, Mr. Chairman.
Okay. It's Senator Overchain.
Yeah, Bill, a couple of questions or comments, I guess. I understand, and I handled these cases, and I've been on both sides of these cases involving doctors and lawyers, and doctors are a little bit different depending upon their specialty. I mean, look at radiologists, for example. Nobody picks their radiologist. And
speak for yourself.
Is a significant interest, I would think, in a radiology practice having a non-compete with a member of that practice. Same goes for pathologists. I mean, who picks a pathologist? And a pathology practice may be concerned about the pathologist taking the hospital with them. I mean, not necessarily taking the patients with them. So, I just would say that this goes, this goes a lot farther than protecting the ability of a patient to choose his or her own doctor.
Okay. Is there other discussion? Is there anyone in favor of this bill? Okay, nobody's rushing up in favor of it, but it appears there's some opposition to the bill. Yes, sir.
Mr. Chairman, members of the committee, Brent Rawlings from the Virginia Hospital and Healthcare Association. We're opposed to this legislation. It's highly problematic for hospitals and health systems that rely upon these covenants not to compete as a recruitment and retention tool. It allows them to offer benefits, compensation, and training. And in exchange for that, they get a return on their investment, which is a commitment to the practice or to the hospital. It's a matter of private contract between the parties, and it shouldn't be interfered with through legislation. There are already protections available under the law, as Senator Stanley referenced. The courts apply a reasonableness test. It should be no greater than necessary to protect the legitimate business interests of the employer, not unduly harsh or oppressive restraint on the employee's efforts to earn a living, and must be consistent with sound public policy. So we submit that there are already ample protections under law. And again, these are parties that are entering into a willing agreement. These are not contracts of adhesion. They're customarily used in the hiring and retaining of physicians. So we're opposed to the legislation.
I think Senator Norman has a question for you.
I also have litigated these, and the ones that you are familiar with, is there consideration recited that is attributable to this covenant not to compete? Normally it's duration, distance, and consideration.
Yes, that is true, and often the agreement to a covenant not to compete is offset by consideration, and often that means higher salary, benefits, et cetera.
Okay. Are there other questions? Okay. Committee operates by motion.
Move approval.
It's been moved that the bill be reported. Is there a second?
Chairman, I second it. I'd like to get rid of all this.
Okay, it's been moved and seconded that Senate Bill
Well, substitute
779
motion.
779 be reported. Clerk, open the roll.
Guys, this is to report.
I didn't want to, he doesn't need to vote. It's okay.
Huh?
I didn't want to vote.
That's fine.
All right, strike the board. Let's try it again. Okay, open the rolls. Close the rolls.
8 ayes, 5 nays.
8 ayes, 5 nays. The bill is reported.
Thank you.
Thank you. Senator Suderline.
No. I'm not done.
Oh, wait a minute, Senator Stanley. You want to try for another one?
Well, sure.
All right, go ahead.
Dumb luck right
We'll
there.
give you one more here.
Okay. May it please, so basically, we had I had a bill in 2016 which.
What bill are we talking about here, Senator Stanley?
Senate Bill 176.
Okay, Senator Cosgrove knows the number. Please.
Thank you, Senator
Yeah,
Cosgrove.
all right, Senator Stanley.
Mr. Chairman, I'm still in shock.
Would you
from the
like
last bill.
Would you like Senator Cosgrove to present the bill
Yes, I
for you?
would,
Since
actually.
He's on top of the number. Okay.
In 2016, we offered Senate Bill 640, which was passed unanimously in the Senate and also in the House, which basically amended 38.2, 3122, and added a subsection F, which created a protected insurance items and annuities insurance where there had been a whole life or a cash benefit for that from creditors. And so we basically made a political statement. But in doing so, what we didn't do and we need to do in the housekeeping is that this is in a direct conflict with 38.2, 3123, previous law which stated that in the case of policies under the term which the right to change the beneficiary is reserved and to which the case of surrender loan of the value the policy is claimed by creditors, the insurance shall not be entitled to protection. Now, what we basically were saying in the bill in 2016, we're providing creditor protection for cash values of life insurance and annuity contracts, which would encourage Virginians to purchase cash value life insurance and annuities. It would encourage a new market, and especially the millennial market, to save for the future and protection of their loved ones. And then one of my insurance agent friends who's going to come up the state wrote me a note that says it also reestablishes the career life insurance agent as a noble profession. I thought that was a good one. So And also, Mr. Chairman, members of the committee, I think we should be reminded that when we have an increase in life insurance and annuity sales, there are positive economic benefits for revenue generation by the state. We have a 2.25 premium tax paid by the insurance carriers directly to the Commonwealth of Virginia. So those benefits right there, what we need to do is just clean up the code so there's no conflict. I say that because we've had 2 court cases in bankruptcy in the Eastern District, the United States Bankruptcy Court, and both of those times, so far, the courts have picked your most recent version, subsection F, as being the intent of the legislature to protect these insurance options, insurance annuities, and the cash surrender values from creditors. And so, therefore, what we just do is like to clean up so there's no more issue and conflict and no more issue before the courts. And that is the bill, Mr. Chairman. And this was my best friend in college, so please do not ask him any questions outside of this bill, if you don't mind. Okay. Sorry, brother.
Well, he's from Virginia Beach, so we'd love to hear him.
Well, I tell you what, I couldn't said it any better than Senator Stanley here.
Oh, that's a bad way to start. That's a bad way to start. So go ahead and say what you're going to say, because I'm sure it's going to be better than what Senator Stanley had to say.
I appreciate the compliment this afternoon, sir.
Absolutely.
Thank you.
Absolutely.
Yes, this bill, again, I brought it to Billy 2 years ago, and again, it established the idea that it's a good social cause for people to have life insurance, okay, and especially millennials, young kids, because what happens is we see too many GoFundMe pages when someone leaves us too soon, and those are the families that end up on our rolls. So we want to encourage Virginians to not only save for their future, which is through permanent life insurance, but also save for their retirement income planning purposes, which are income annuities, which the gentleman referred to earlier. So again, as Billy said, it's come up in 2 cases already.
Dude. You going to tell him my nickname too?
No, not a bit. We agreed not to discuss those items. But
yeah, it's Billy. Scored up.
Back to the point. This just, again, cleans things up, and it will save time and money on constituents who their attorneys in divorce cases or in bankruptcy cases are arguing about whether it's protected or not protected. So,
well, thank you. You did that so much more artfully, and you might have breathed life into this bill with that testimony. So,
thank you very much,
Thank
sir.
you so much.
Well, I think you lost open chain because you said it would save time and monies from lawyers. So there you go.
Is there anyone who wishes to speak in opposition to the bill? The bill's before us.
Billy is for the bill.
It's been moved and, do I hear a second? Been moved and seconded that Senate Bill 176 be reported. Clerk, open the rolls.
Hey, Ben, put a little hustle in your
Close the roll.
There you go.
13 ayes, 0 nays.
Thank you, Mr. Chairman.
13-0. Bill's reported. Thank you, Senator Stanley. Senator Suderline.
Thank you, Mr. Chairman. I've got Senate Bill 513. Senate Bill 513 amends a significant part of the code relating to 911. It's all related to the deployment of next generation 911 and how localities will work with that. It also changes the funding process for localities and originating service providers to fully fund the transition to next generation 911 and implement it in July of this year. The board approved 911 funding formula. I also have the state's 911 coordinator, Steve Marsloff, is present if you have any questions about some of the very complex parts of the legislation.
Good. Thank you, Senator Suderline. Yes. Yes, sir.
Hi, I'm Steve Marzoff. I'm the 911 director for VITA, working for the state to deploy next generation 911. I'd be happy to answer any technical questions you have.
I guess my only question is,
yes, sir.
Does this have a cost, and if so, is the cost covered?
The cost is covered by the existing 75-cent surcharge on wireless phones.
So there'd be no fee increases and
No
the money's
fee
there
increase
to
being
accomplish
recommended.
this?
That is correct.
Okay, any other questions?
That's what I'm carrying.
Any questions for the patron? Anyone opposed to this legislation? Been moved and seconded that Senate Bill 513 be reported. All those in clerk, open the rolls. Close the rolls.
15 ayes, 0 nays.
Thank you very much.
15-0. Bill's reported. I believe that completes our docket, so, Senator Cosgrove, I'm sorry. How did I miss you? Oh, I marked you out already. It must be a good bill. What do you got, Senator Cosgrove?
Mr. Chairman, I have Senate Bill 244 for your consideration. Mr. Chairman, what this does authorizes a bank to operate a branch office under a different name if that name contains the language clearly indicating that it's a branch office of a particular bank or division of the bank. Currently, a different name may be used by a branch office if it indicates that it's the branch office and indicates the bank in which it was a branch. Mr. Wells is here to speak to the issue if you would so care.
Okay.
Move approval.
Is there anyone opposed to this bill? I think we all understand what the bill does. Oh, Reggie, you, okay, I just thought since you got up, maybe, okay. It's been moved and seconded that Senate Bill 244 be reported. All those in favor, oh, I'm sorry, clerk, open the rolls.
Can I do this here? Just vote me yes, please.
Close the roll.
I'm trying.
15 ayes, 0 nays.
That bill's been reported. Thank you. With nothing else come before the committee will rise.